advised, the Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for cause number CV230409, family law case Kim versus Pak. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. We also have a number of young people here watching the argument today. Welcome to you all, so it would be helpful if you explain to them who you were as well. Each side will have 20 minutes in which to present their argument. Appellant's counsel is responsible for watching the clock to reserve any portion of that time for rebuttal should you choose. Also, we have read the briefs. We have discussed the case this morning in conference. We are familiar with the facts. Please bear that in mind during your presentation. So at this point, Mr. Berkshire, are you ready?
Yes.
Please proceed.
Morning, may it please the court. Keith Berkshire, attorney for the appellant, Dr. Alex Kim. The case at hand is one of the cases that the Arizona Supreme Court discussed in Cockrell, where it said that there are cases that are very simple, which is cases where there is 100% passive income, and there's also cases that it's 100% the active effort of the parties that makes the income. This is for pre-existing separate property businesses. And as the Supreme Court said, we can't just treat those as those are the only cases, because most cases actually fall somewhere in between, and therefore some type of apportionment of both the increase in value and the revenue during the marriage, the profits of the business during the case, have to be proportioned. If it was just a simple, I own a McDonald's and I've never set foot in the McDonald's during the marriage, I owned it pre-existing and I just cashed the checks, that's a really simple case. That the analysis is very simple. The same as if 100% of the income from my separate property business was due to my labor. That's very simple as well. But this is one of those cases where it's not. There's no question here that my client had a very profitable business as of the date of marriage. He was making about $1.5 million a year from Amos, I think that's how we pronounce it, from his medical practice. And according to our expert, he had a net worth of around $4.3 million.
When you say he was making $1.5 million, was that his salary and something on top of the salary, or his salary as a vascular surgeon?
Yeah, it was a combined profit of the business, and that's also included a component of his work.
Mr. Berkshire, below, we were arguing about was he a vascular surgeon? Was he some other kind of surgeon? Have you waived that on this appeal, that we should consider vascular surgeon wages, not this other?
No, we specifically included in our brief the difference on this, and I would point out that in the child support order, the court actually used the $325,000 salary for the phlebotomist.
So you disagree with the trial court's segregating before and after, since the disciplinary action came after?
Well, the trial court at the end of the day didn't actually use that, and it actually specifically stated that because it determined that everything was community property that was purchased from the revenue from Amos, that it didn't actually get into that. It specifically said, I'm only going to get into what he is for the child support. So from that standpoint, because the trial court really didn't rely on that distinction between being a vascular surgeon and phlebotomist, I think is the pronunciation. I really don't know.
Not phlebotomist, phlebologist, okay.
There's an OL in there. I don't think again, but even if the court used the vascular surgeon
and
pay.
what I'm asking is, do you concede that for the pre-divorce stuff we should be using vascular surgeon pay? Or are you still contesting that the entire thing should not be considered vascular surgeon pay?
I guess I'm not following why okay, sorry, I thought you meant pre-marriage. Sorry, for the pre-divorce. I think in either circumstance, if you even considered him vascular surgeon pay, the community still ended up with more than its proportionate share.
What I'm asking you is, can we, for the purposes of our analysis, assume vascular surgeon pay when we're doing our calculations? During the marriage.
I understand. Yes, you can, because even if the court used that number, which I think then come up with a lead of like 2.9 million, the community still ended up too highly paid.
Well, let's start. Can I start? I just want to get some numbers down. A vascular surgeon, there was testimony, a vascular surgeon would make how much annually?
I don't remember the exact number that Ms. Meisner used. I thought it was in the sevens.
Okay.
Was the number.
And wife in this instance, and when you say in the sevens, you're talking 700,000?
700s. They was 325 for the phlebotomist, and I think it was in the sevens for the vascular surgeon.
Okay. And wife claimed that she was working in the business, so she's entitled to
No.
her pay.
She claimed that she was working. I mean, wife made this fallacy argument that somehow that their ceremony in 2012 meant something.
I get that. From
She
the
only-
time of marriage, is there
she
any
worked-
testimony that she was working in the business and not getting compensated?
No, the testimony was that she worked for an extremely brief time, according to Ms. Meisner, after the date of marriage, like a matter of couple months. That was it. Her claim, and specifically in
And
the
Ms. Meisner was going with the date of marriage being religious ceremony.
Well, she said that, quote, as a human, she considered the 2012 to be the important date, which obviously statutorily it's not. But she admitted that wife after the date of marriage, if she worked there, it was extremely limited, matter of a couple
And when you
months.
say she, you're referring
Wife.
to Meisner.
Meisner testified
Correct.
that wife worked there for
Okay,
maybe
how
a
many,
month or two.
do we know from this record what are the gross profit, the growth, I don't want to say profits, the gross distribution of revenue from the business to during the course of the marriage?
Yeah, the testimony was that it was essentially undisputed between Meisner and Hughes that there was an excess of $4+ million that came out of Amos that went into these, to fund all these business buildings.
And if we attribute 700,000 on the low end for the court through the 5-year marriage, that would be 3.5 million would be deemed, that's community income. That 3.5 for the
Close.
course of the marriage would be
Yeah, and as
his salary.
And as as both experts testified, you would have done that in a post-tax. It's not a comparison to the 4 million distributions they would have done in a post-tax, which would have taken it down considerably, as both of them testified to. And the community also got the additional 300,000+ over the course of the marriage from the wages that would have had to have been accounted for in there as well.
Okay, and how do we account for, you said this is post-tax, but we have some issue with how the taxes were paid in this circumstance, don't we?
Well, one of the big issues here in this is obviously during a marriage, you are going to do what benefits you from a tax standpoint. I mean, it would be kind of foolish not to. I mean, most people in most small businesses, S-corps, they pay the most and pay it through distributions versus wages because you save like 6% on employee side of taxes and so forth. So they're going to take advantage of that. But this was all a tax planning strategy, again, that doesn't affect at the end of the day what the proportionate amount that the court should give to the separate property holder. So people do tax planning strategies all the time, and that's not dispositive under Roe, under Baum, to talk about how you treated it from tax purposes. It doesn't change the character.
Can I get to, let's assume once we've done all the calculations that's attributable to the community, whether after tax, whatever, and we decide there is an additional, let's just say $1 million of revenue that's generated from this asset that's after the community's been compensated based on the work as a vascular surgeon or whatever else. So the 1 million in profits, what percentage of that is attributable, if any, to the community, and what percentage is attributable to the separate interest that was existing at the time of marriage?
So this was the issue, is that the starting point is that Mr. Hughes addressed that. So Mark Hughes addressed it was a 2/3, 1/3 to the community versus separate.
So
Ms. Meisner,
2/3 is attributable to the efforts of the community, the revenues.
correct.
Okay.
Ms. Meisner didn't do that analysis at all. All she did was a reasonable comp and said, here's what you should do. The real problem we have with Ms. Meisner's report is frankly is the starting point of the report, that it assumed, she testified to this and it's in a report, she assumed that because he didn't segregate it at the time the business gave it to the parties, put it in bank accounts, however, that the distributions were commingled from day one. And that's the problem with the starting point. This isn't an issue of tracing where it went into an account, he can't trace it. Meisner assumed that every dollar that came out of Amos was already commingled the second the check was written. So there can't be a tracing when your starting point is that everything is pre-commingled.
So, Mr. Berkshire, would you have objected had she said, yes, this approximately $4 million, we're going to say half is community, half is his, and then she says, we can't trace it, all of the 5 properties purchased during the time of the marriage are community, would you have the same argument?
I would. And the reason, again, this is an interplay between tracing case law and business apportionment case law with Cockrell, Rauschenberg, and Rowe. And I think one of the biggest things that came out of Rauschenberg case, I think if there's paragraphs to read in Rauschenberg, it's 37 to 40. And I think 40 is the big sum up of Rauschenberg, where it says, the principles from Rowe teach us that the 2/3, 1/3 ratio in allocating the growth of the business applies to the profits. It would be an abuse of discretion for either the community or separate property to receive more than its proportionate share of the combined total. So it's talking end result, because these things aren't ever going to be able to be traced.
So when we look at Ames, it decreased in value. It started out at $1.5 million. When they came to the time of dissolution, it was worth approximately $750,000. In both Cockrell and Rauschenberg, the actual business increased in value. We're not talking about that here.
Well, I think it actually went down farther than that, Judge. I think it started at 2.5
Okay.
versus 1.5 was his income from it.
Okay.
But I think it went from 2.5 to about 700. But again, that doesn't mean that he doesn't have separate property income. Just because a business went down in value, so I own a car dealership that I make $100 million a year on, 10 years later I make $90 million a year, I still make $90 million a year on it. This company still had a separate property component of income that the court disregarded and that Meisner disregarded.
I want to go back to Judge Catani's question, because I don't think we got the clear answer we were looking for. If we're saying once you subtract out of the revenue distribution, and we'll just, what was it, $4 million, and you subtract out what the community during the period of time should have been compensated for because of his salary, and let's say it's $3 million, that leftover $1 million, is that completely his separate property?
No, I think it still could be proportioned. I think the overall has to be proportioned.
How do you come up with that? Why? I mean, it makes sense, but is that a number? How do you get to 1/3, 2/3?
That was that's the problem in most of these. I mean, even in Roe, when the court did 75-25, or in Rauschenberg, the 2/3, 1/3, it's basically an analysis by the business expert and determine. It's the same as reasonable comp. They go through and look at the data and talk to the people and see what they think is relevant to come up with this number.
But it's irrelevant. The effort that he expended during the marriage has helped generate profits beyond simply his salary. Is the idea that why the community is entitled to a portion of it?
Correct. I mean, this is the whole concept that went from Cockrell to Rauschenberg in the first place, was adequate comp is not enough. We got rid of the all or none rule, that if you were adequately compensated, you shouldn't get part of the business that you helped build. That was the point of this. The issue is, this is the all or none rule. This is specifically the all or none rule that Cockrell said we can't do anymore, because in Cockrell, they said, okay, if a company is mainly community effort or mainly separate effort, it was all or none to one of those two things. Here, that's what Meisner did. She said 100% of the distributions from a pre-existing business she presumed were commingled before they ever hit a bank account. And that's the problem, is they didn't proportion it. So the interplay here, and I think the clarification that's probably needed in the law here is this a tracing, or is it simply you still at the end of the day have to do what the Supreme Court said in Cockrell? You have to do your proportionate amount somehow and to achieve substantial justice. I know it's really super specific, but it's, the idea at the end of the day, what this court said in Roe and this court said in Rauschenberg was, you can't get more. One of the estates should not win. One of the estates should not win wholeheartedly. Separate shouldn't win. Community shouldn't win.
How would we evaluate it if they'd said, if one expert comes in and says 50% is attributable to the community, 50% is attributable to the separate interest ahead of time, and one expert says 2/3 of the community, 1/3 to the separate? What would be our basis for?
So I think that's where this actually gets into, some of the case law about when there's kind of a doubt, you go in favor of the community. And I think that's a discretionary thing for the court to look at and say, I believed this expert more, their rationale was more on the 2/3 versus half. Here, neither expert said it's 100%. Neither expert said 100% of all the profits that came from Amos were due to my client's efforts. He had 40 employees. So unless those employees aren't doing anything, this can't be 100% him. And neither expert said that. That's why that even Meisner said that his comp should be 700 compared to 1.5 million. If we just say his comp is 700, the first year he's making 1.5 million, well, at least 700 of that is probably his separate property profit of this company. And again, I mean, the starting point obviously is 25,213, that, royalties, rents, profits of separate businesses remain separate.
And your client's expert said 2/3 to the community, 1/3 to the separate, or the other way around?
He said 2/3 to the community,
And
1/3 to the separate. So, I mean, they weren't, horrifically off. What the experts both...
Just so I can understand, if that's the case and we're going 65 and 35, 65% community, 35% is separate, for the 5 contested businesses, does that mean the community has a 65% interest in the business?
So the liens were calculated, I mean, the endovascular one was a little different because they calculated, it's a little different. But essentially, yes, essentially that's how Mr. Hughes calculated out each of the liens on these business buildings, that the lien was calculated based on a percentage of the contributions minus what the community received already. So if the community was entitled to 65%, they received this $300,000 plus in actual salaries that was, calculated off of that. But essentially, yes, Judge McBurney,
Do you have to consider some amount of effort in as a real estate expert, or the development of the property that would presumably be also a community?
So that's what the 65% was across the board of what he was saying that he was doing. So Mr. Hughes was testifying that the 2/3, 1/3 of the efforts of all this stuff was every effort he was putting in across the board. So, but again, that would be more of an issue that the court didn't address at all, and the calculations of that, no one presented on it.
Does it make the businesses community businesses with a lien to the husband for his 35% sole and separate, or does it make it a separate, a community business?
Husband's argument was that because nothing went into a jointly titled account, it was through trust that he owned, that where wife's name was never on, the funds came directly from his premarital Amos business, that they were separate property with calculated liens.
But that ignores the salary that ignores the salary that should have been the component that should have been attributable to the community.
Well, but the community, again, they got salary plus that went into joint accounts that was pieced off in the calculations. It doesn't ignore it from the standpoint it doesn't calculate it in. It calculates it in. But obviously the community lived off my client for 5.5 years of the marriage. He provided the income, they put the expenses, that was the money that came in, that they provided it. But at the end of the day, I mean, again, what these cases, this is a line between does he have to trace and does the court have to do what Cockrell and Rauschenberg say, which is to, at the end of the day, do substantial justice? Because how do you ever trace? I think this is the big problem in this, is I have a separate property law firm. I get married. Do I have to go hire Mark Hughes or Julia Meisner the day I get married to come up with my reasonable comp and put that into a community account? Let's say I put $100,000 too little each year into it and it goes into my distributions. Now, because that money is commingled from the get-go, I can never own separate property. That gets around the concept that the Supreme Court said in Porter, which is these two estates are of equal importance. The community's important, the separate's important. If you say that every instance is held against the separate property holder because he didn't compensate, didn't delegate wages enough to the community, even though there's a great tax reason not to, and it actually helps the community to not do that, then the separate property holder always loses unless the business is 100% passive. That can't be the law, that the separate property always loses. What if he in good faith does 200 salary, but it should have been 300? Well, that extra 100 commingled these accounts, so you automatically lose. That's not what this court has repeatedly said, that at the end of the day, it still has to proportion the profits, and it still has to achieve substantial justice. Giving 100% of everything to the community here didn't do substantial justice, because his estate went from $4 to $2 million, the community went from $0 to $7 million. That's not substantial justice. I'm happy to take your question, or I can save my minute.
Save your minute.
And I had a question on that.
We'll come back.
Something for you to think about. His question, if it's separate property with the community having a lien as opposed to if a whole bunch of community funds were used to purchase it, is it community property with husband having a lien? Just
And
curious
we're going
about
to
that.
add 3 minutes to Mr. Berkshire's time, and we'll add 3 minutes to Ms. Wilkins' time.
Thank you.
So you have the opportunity to answer Judge Catani. Ms. Wilkins, when you're ready.
Thank you, Your Honor. May it please the court, my name is Amy Wilkins Hoffman. I am here representing Appali Hyun Pak. This is a tracing case, and it's also a burden-shifting case. And with the court's indulgence, I'm going to start with a quote from Ruschenberg. It's paragraph 35, which is excluded from Mr. Berkshire's list of key paragraphs in Ruschenberg, but I think it's important. It says here, it was within the trial court's discretion to start with the presumption that all of the growth in DMM, separate property, was community property, and then look to the evidence presented by husband to see if he had managed to overcome that presumption.
Why would that be a logical presumption if you start with an asset that has some value? Nothing about the separate business generated profits independent of the efforts, the salaries that were generated and the efforts that were exerted during the marriage?
Because our case law puts the burden on the spouse claiming that property acquired during the marriage is separate to show that it is separate property.
We're talking about revenues generated from an asset that existed prior to marriage. And some of that was attributable to efforts of the community, but isn't some of it attributable to the asset that was in place before the marriage?
Yeah, I think you would have to have an expert calculate what portion of that is increased in value from the inherent qualities of the business versus what efforts were put in by the community.
There isn't a claim against the business. There isn't a lien on the business now based on the increase in on the business. I want to circle back to, you said this is a tracing case. Did the parties have any other source of revenue besides the business?
The answer to that is the money primarily came from husband's work, which, vascular surgeon or phlebotomist, that's where the money came from.
Let's focus.
Sure.
Is there any other source? There wasn't a trust fund out there. There was nothing else. We're talking about revenues generated from this sole and separate property
That's
business.
correct.
Profits.
Yes.
Profits. And if we take the profits pie and we say, okay, as a vascular surgeon, he should have been paid $700,000 plus yearly attributable income, right?
Yes.
So then there's profit distribution above that.
Correct.
What more tracing do you need to make an apportionment determination?
Well, I guess the reason I paused is because when I think of tracing, I think of an asset that was purchased during the marriage, and you can trace it back to separate funds.
And if we agree with you, Amos is separate property. Everything transferred out of Amos, there's no claim on that business.
That's right.
Everything transferred out of there was profits derived directly from there.
Correct.
So if we take that as step one, there are these profits that are above salary. What more do we need to do?
Well, in some cases, if we're talking about apportionment, in some cases, the community might be...
Okay, we're not talking about other cases. We're talking about this case. And in this case, Ms. Meisner starts off with, nope, it's no tracing. But that's not true. We know exactly how much money was generated by the business for the course of the marriage. We know exactly how much should be attributed to husband's income as working in the business. So again, what more do we need for a tracing analysis to start for an apportionment determination?
The issue here was, what are we going to do with this money that went into a community account and got commingled and got used to purchase all of these other properties?
But let's say there's the revenue that was generated after the salaries. I'm just pulling a number out of thin air. $1 million that's revenue after everybody's salary has been paid. the joint expert seems to be saying, we don't know. She assigns all of that to the community. It's $1 million, and under her analysis, all of that is attributable to the community. She's not saying anything is attributable to the value of the business at the time of the marriage.
The way I understand it is it's almost a chicken and egg problem. Meister worked backwards and said, you got this property, like SKS, whatever it bought, Earl, and worked backwards and said, where did the money come from, as you do when you're tracing. Okay, it came from 2010, it came from this E-Trade account, and none of this is factual. I'm just using an example.
But why can't you start from the other end, where you said, we have $1 million that was generated from this business, and the only thing that happened to those funds, they were used to purchase, they were used to pay community expenses, and there was stuff left over that was used to purchase another asset. Why aren't, if those were all separate profits, why wouldn't that interest in the new building be entirely a separate interest?
In the case where you have that scenario, where it's just money above the reasonable compensation, and it went directly to go buy an asset, I think you would absolutely be able to trace it back, and that's not what happened in this case.
Oh, wait a minute. We use circumstantial evidence all the time in these cases when they talk about commingling. And we simply say, we look at circumstantially what is there. And we know for a fact how much money was taken out of the business and distributed to the community. Some of that is separate because it's above what would be normal compensation for a vascular surgeon. And I'm still struggling with why you should presume that money above the compensation would not be his separate property.
Well, if you look at what was given to wife as the down payments for these properties, it's actually less than the reasonable compensation. And what Meisner did was the total recapitulation method, which looked at, hey, if earnings exceeded expenses, where did that money go? And husband didn't meet his burden to trace it back and say, no, this was actually my separate property. Also, the trial court was within its discretion to say that this percentage, the 65%, wasn't based on anything. That's absolutely the trial court's discretion, and to find that husband didn't meet his burden.
But he couldn't go to zero.
Yeah, that meant Meisner's view was it's zero. I understand commingling if there's income from a trust or from somewhere else and you're commingling, we don't know where this money came from, but here we know it was generated from a business that was in existence at the time of marriage. So anything left over after expenses is revenue from the separate business, and here husband is just saying 2/3 of that belongs to the community, but 1/3 of it should remain the separate revenue that belongs to his separate property. Why doesn't that make sense? I'm not understanding how commingling affects the revenue generated from a separate business that hasn't gone anywhere other than to pay community expenses, and then there's been money left over that's purchased an asset.
Well, Amos was awarded to husband. Husband retained any value that was in that business. It was not
Right, but what
transmuted.
are we doing with the revenues that were generated from it?
The revenues that were generated from it, either, well, as Meister found, there should have been a lot more money in the community had it not all gone to these properties.
So if we were to assume that he made vascular surgeon wages, and let's just say the $4 million, $2 million of that were wages, and that was the fair market value, and we have this other $2 million hanging out there. How do you characterize this other $2 million? She went backwards and said it's community, but Ames distributed it out into different accounts to buy separate property assets. So just by transferring it out of Ames, it lost its character as separate property?
I think that's right, Judge, and I think the reason why is because...
Doesn't that violate the statute that says profits generated from sole and separate property or remain the sole and separate property of the holder?
No, because once they're commingled...
Okay, you just keep coming back to this
I do.
commingling, and I don't see it, so you're going to have to, come up with a better answer, I'm afraid, for me. I don't see how it's commingled. When it's commingled, we recognize that there are salaries involved that we have to attribute to those monies. But it's not commingled with other streams of revenue. It is just the business's revenue, right?
Right. But by failing to segregate, for example, I mean, husband was a sophisticated party here, right? He set up trusts, he set up these LLCs, he set up this 2010 account, which wasn't directly appealed, that the 2010 account wasn't community. All of these income streams, and I think I see your point now, are coming from Amos. So you're saying, well, they got popped in this account, but I can still follow them. But then money is also coming from the E-Trade account. The 2010 account is being used for all sorts of different things. Money is going back into Amos. And
are we assuming that all expenditures coming out of that account, besides not going to these businesses, were for community expenses? I mean, besides the 5 properties, were there any other monies being spent on separate purchases?
I don't know the answer to that off the top of my head, Your Honor.
Because that would make a difference, but I don't see anything in the record where there were separate expenditures. So we're assuming that all expenditures out of this joint account are for community expenditures. So are we talking about the pro rata share, just like Mr. Hughes articulated?
You know, in thinking about this, I want to talk about pro rata a little bit. They're saying apply 65-35, and then you can apply that percentage to every single dollar that goes into 2010, goes into the SKS account, for example, or any of the 5 property accounts, and you can just keep applying that share over and over every transaction until you get back to something that is a number, and that's how you do it. It obviates tracing for a piece of property and getting it back to the source. Because if you're going to say that money were extensively commingled amongst these accounts, and some portion of that is community and some portion is separate, and that's the commingling.
But commingling only matters if some separate bills are being paid, or if some separate income is coming in from some other source. I'm still not following it's Judge McCurdy's question of, and we just have $1 million of revenue that was generated from a separate asset. And it's not being commingled with anybody else's income. It's not paying any separate expenses. It's just sitting there. It's paying community debts, and what's left over is purchasing an asset. Why doesn't that remain a separate asset?
I think in your example, the assumption is this piece has been segregated as separate and stays separate, whereas this money that was being paid out from Amos has a community and separate component, and because it wasn't kept separate,
that's what you
it's
do with the
commingled.
prorated
Yes,
share.
can't we quantify that division, though? We talked about vascular surgeon wages times the number of years of the marriage, less expenses. I mean, all of these things are quantifiable, are they not?
Yes, I think so.
Okay, so in tracing analysis, it is so transmuted that you cannot do that. That's the whole purpose of the commingling doctrine. There's just no way to do it, but you just said we could do that.
I think that you can calculate the reasonable compensation due to the community in this case, if you accept Meisner's position. But then how are you going to just calculate, okay, 2.9 and 4, there's a percentage, and every dollar in, every dollar out? Meisner testified that was absolutely impossible and led to an unreasonable result, and it was within the trial court's discretion to agree and assign weight to Meisner's opinion that it wasn't possible, rather than to Hughes, who purported to use a computer.
Actually, we review these de novo.
I'm aware,
So,
Your Honor.
We get to say whether or not, what would be an acceptable starting point. And I tell you, I'm really struggling with the notion that when you say commingling, when you're not commingling different income streams, it's one stream, and we can carve out of that stream a community component. I'm not sure how that equates to commingling. And again, even if it was commingling, we trace in commingled accounts, we can do that with circumstantial evidence. So why wouldn't that be the same thing here? We know what went in, we know what went out. Why don't we have enough information?
I appreciate the clarification on de novo review, but my point was simply that this court also defers to the trial court on credibility and weight to give evidence. And here,
What's the credibility assessment that we're deferring to?
the credibility of the experts and whether or not to accept Meisner, who is a neutral.
But
joint
Meisner
appointed
is saying, I'm not finding any revenue is attributable to the separate interest in the business that existed before marriage. We're going to defer to that view?
Meisner found that 2.9 million of the 4 million that husband earned over the course of the marriage was attributable to husband's work.
Right, but I'm talking about after we've taken out the salary. That everybody agrees that's community. But beyond that, there's a revenue that was generated in addition to the salaries that should have been that can be accounted for. That revenue, Meisner is saying 100% of that is community, attributable to the community. What are we deferring to? What's her basis for saying none of that was derived from the separate interest of that business that was there before marriage? I'm just struggling with what we're deferring to.
Well, if it's husband's burden to show which portions are separate in community, and the trial court did not find Hughes's 65% based in anything, then we can defer to the trial
it's based on
court's-
something. It was an existing business. He could have said 50-50. He gave a number that's arguably generous to the community. And I understand it's not an exact science, but there's certainly some value that was there that's attributable to the separate interest. And I don't know how we can defer to an expert who says there's zero. I can't come up with any value that exists that was generated from a business that was already in existence.
But I don't know if Meisner said there was no separate property value. She calculated out of the $4 million in money that husband generated that the community had been short, I don't think this is a word, shortfalled $1.69 million. So I don't agree necessarily that Meisner found that no dollars were attributed to separate property and husband retained the separate property, Amos.
But what happened to the revenues that were generated?
What happened to the revenues that were generated, I believe, they went into this joint account, 2010, and then were dispersed.
And you agree that some of those revenues go beyond the amount of the salaries?
If you look at the purchase price for these properties, it's actually less than the undercompensation that Meisner opined the community received. I hope I'm answering your question.
Let's do this like a two-step.
Okay.
First step, we've got Amos.
Yep.
We have value of $750,000 confirmed by the trial court. We have profits over the period of the marriage. Let's just say $1 million because math is not strong with me. So that $1 million goes into a community account.
Yeah.
Where does Meisner account for the separate property $1 million in her suggestion, and where did the trial court account for it in the decree? Can you point me to that?
I would say that what Meisner did was work backwards and look at what was purchased. And no, I'm trying to answer your question because I don't think I can point to actually Meisner segregated $100,000 of that million and put it off to one side. And so maybe that's answering your question more directly. I think what Meisner did is work backwards and say, where did the source come from?
So we've got these 5 properties, and they were purchased during the community, during the marriage, so they're presumed to be community. If husband overcame the presumption and said, no, I had this $1 million and this one property is separate property, the rest are community. Does he have to do that, or could he move, I've got a separate property interest in each of the 5?
I think that if husband had met his burden in one, then the court could have done a community lien or whatever it
So that's
was
up to
with
the
that
court.
one. Yes, absolutely.
And the court here found he did not overcome the presumption of community property. So would he have a separate property lien on each of the 5 properties based on that $1 million that we don't think Ms. Meisner accounted for?
I think that's probably fair, yes.
Okay. Thank you.
All right. If there's no other questions, I think I'm going to retire. Thank you.
Thank you.
Thank you, Ms. Wilkins-Hoffman. And Mr. Berkshire, we're going to start at the beginning, and Judge Catani is going to ask you his question. Hit it.
Are the assets or the properties that were purchased, are you saying they're separate with a community lien, or that there's a presumption it was purchased during the marriage, so they're community with husband having a lien?
The position my client took below was that because they came from the Amos distributions, that they're presumed separate with a community lien. That was what the calculations that Mr. Hughes did on them. Again, leaving off endo.
Does that make sense, though, if more of the significant percentage came from community funds and they're purchased during marriage? It kind of matters if there's an appreciation in value.
I mean, at the end of the day, I think one of the things that why community lien versus separate makes a big difference, the titling on it, is the ability of the court to do anything with it. If something's separate and there's a community lien on it, the court can't sell it, the court can't, they can hold you in contempt. That's all the court has the authority to do under like Weaver and the Supreme Court cases on that. So I think it makes a difference at the end of the day, titling that the community, if it was separate property with a community lien versus a community asset with a separate reimbursement, there's an issue from enforceability of judgments. I think at the end of the day here, the calculations of these liens, it didn't really matter which way you classified it because it was a proportionment of the profits that bought it and then the growth of them. So it could be a distinction without a difference from a pure dollar amount. It's an important distinction from your rights to collect against separate property versus against community.
But from what I'm hearing is we wouldn't be here if the court had simply awarded it as community property and imposed the corresponding lien to represent your client's separate interest.
I think I'm hesitant to call a separate lien. I'm hesitant to use those words because of like Flower and Edmoden and so forth that get this into these reimbursement claims of separate property. I'm hesitant to use that term versus a community lien against separate property is in the statute.
Here, these were placed in title in husband separate.
They were placed in title in an entity's husband was the only person on from a corporation commission standpoint through, and some of them through trusts.
But are we bound by the trial court's finding that he failed to meet his burden in proving they were separate property?
No, not at all. I mean, again, it depends where you start from these distributions. I mean, this is the big issue of, is this a tracing issue? Is it a proportionment issue as you've gone into for the last 45 minutes, is what is the presumption of distributions from a clearly profitable separate property business at the time? Do you just proportion it and where's the presumption? If it's 99% due to his efforts, I mean, is the 50% mark where you start saying it's community or separate? I don't have an answer for that because there's not any case law that really discusses what that is. Now, it is profits from a separate property business, as Judge McMurdy said, under 213, so you could definitely start there. But the dollar amount at the end of the day, I'm not sure made a huge difference because, again, the court, Meisner didn't have an analysis to contradict Hughes starting from the correct standpoint. So one of the important points, question you asked was that on page 24, Meisner's specific undercompensation after consideration of the salary and taxes was $1.69 million. So that's what she found the court, it was 2.8, after taxes 2, but after the salary wages they received was 1.69. It lists the schedule, it's on 24 to 25. So that's the number we're looking here out of the 4 million. So the problem is that there was no argument about this because Meisner didn't get into it. They didn't calculate this at all. So one of the things I think why this is somewhat semantic is paragraph 6 of Rauschenberg, where there's been CLEs all over the place that talk about paragraph 6 of Rauschenberg. It's this, it's referred to as a clawback, Okay, paragraph 6 basically says if the community's overcompensated, you can make a claim to get the money back. And so is that now this separate property lien that we're talking about? That's potentially it, but there is an argument that comes directly out of Roe through Rauschenberg that talks about if the community's received too much, the separate property holder can get it back during the equalization of these assets that were purchased. So I think that is the, again, I'm hesitant to use separate property lien, but it could be a reimbursement to the separate property holder of the excess that went into the community. But at the end of the day, it's substantial justice in some pro rata standpoint as described in Cockrell.
Thank you, Mr. Berkshire.
We thank you both for your arguments here today. You've given us a lot to think about. We will take this matter under advisement and issue a written ruling in due course. At this point, we are going to take a brief recess to get the courtroom reset for our next argument.